Good evening to all of you. My name is Raj Kumar. I'm the founding Vice Chancellor of OP Jindal Global University. I would like to extend a warm welcome to all of you to this evening's colloquium on law, judiciary, and the justice colloquium on the theme Supreme but Not Infallible, Reflections on the Future of the Supreme Court of India. I have with me a very distinguished set of former judges of the Supreme Court of India, as well as academics who will join me in this discussion. But before I formally invite them and also introduce them, let me give a brief introduction to the theme of this evening's colloquium. The Supreme Court of India is not just a forum for providing access to justice, but is also the supreme center for legal dispute resolution and the final arbiter of the interpretation of the Constitution of India, interstate disputes, or important questions of law and justice. It is the final forum for statutory appeals and individual disputes of facts, and also being the final authority on matters of justice. This perhaps makes it the most powerful institution of our nation. However, most importantly, in a country based upon three pillars, the legislature, the executive, and the judiciary, the Supreme Court is also the moral compass of the nation, the protector of the Constitution, and the guardian of the rights of the citizens of India. While the judiciary primarily drives justice for the people of India, it is also responsible for demonstrating leadership to guide the judicial structure and the legal architecture and the governance mechanisms across the country as well. The recent years have showcased landmark and progressive judgments by the Supreme Court of India. However, there have also been outcomes which have highlighted the vulnerabilities within our judiciary. It is only inevitable that somewhere along the way, the Indian judiciary will go through various challenges which impinges on issues relating to social expectations, institutional credibility, and the impact of the court on the life and evolution of the state and society in India. After all, the Supreme Court is supreme but not infallible. However, with every rise and fall comes an opportunity to evolve and to strengthen the interpretation of the Constitution to meet the demands of a progressive and liberal world order of the 21st century. Questioning our systems is the very essence of the democracy we live in. Has the Supreme Court fulfilled the social revolution as desired in the Indian Constitution? Is our legal architecture still relevant in these times? And what kind of access to justice related reforms are needed, especially given the systemic failures that has also resulted in some of the vulnerabilities that we're facing on account of COVID-19? While sound judgments have been passed in recent years, is there a robust mechanism to ensure the implementation and enforcement of the law? From healthcare rights to data privacy, do we need to reinvent our imagination for justice delivery mechanism? Is it time to embrace technology as triggered by the recent events to expedite the delivery of justice? Should the Supreme Court of India become more like a constitutional court? These are some of the very fundamental questions that we must address to strengthen the state of justice and democracy in our country. The current pandemic has only given us an opportunity to understand the cracks within our system and fill the gaps to build a more resilient and brighter future for our nation. Therefore, this colloquium is an important platform for us to reflect on the future of the Supreme Court of India. I have great pleasure in welcoming and introducing my distinguished guest today. Honorable Mr. Justice Justi Chalameshwar, a former judge of the Supreme Court of India. He retired in June 2018 as the second most senior Supreme Court judge. He obtained his LLB degree from the Andhra University, Visakhapatnam in 1976. Justice Chalameshwar served as an additional judge at the then High Court of Andhra Pradesh. Later, he became the Chief Justice of the Guwahati High Court in 2007 and was also served as the Chief Justice of the Kerala High Court and was elevated as a judge of the Supreme Court of India in October 2011. He was, of course, known as a distinguished judge, but also who somebody spoke truth to power. We have with us Professor Seetal Kalantri, a clinical professor of law at the Cornell Law School. Professor Kalantri writes in the fields of comparative feminist legal theory, international human rights, and empirical studies, of course. Her scholarship seeks to identify how legal norms aimed at promoting human rights sometimes undermine gender and racial equality when they migrate across national borders. Informed by a decade of human rights practice in international and domestic courts, she uses interdisciplinary methods to understand what mechanisms best promote state compliance with international human rights law. She also studies why judicial institutions, particularly in India, fail to effectively provide justice using empirical methodologies, including such methodologies for working and understanding the Supreme Court of India. She received a Fulbright Nehru Research Scholar grant to conduct research on the Indian Supreme Court, as well as won several awards and grants for her work. Thank you, Seetal, for joining us this evening. We have with us Honorable Mr. Justice Madan Lokur, a former judge of the Supreme Court of India. He studied in Modern School, New Delhi. He obtained his LLB degree from the Faculty of Law, University of Delhi in 1977. He has vast experience in civil, criminal, constitutional, and service laws. He was appointed as the permanent judge of the High Court in July 1999. He also functioned as acting judge of the Delhi High Court before being transferred as the Chief Justice of the Guwahati High Court and High Court of Judicature at Hyderabad. He was elevated as judge of the Supreme Court in June 2012. He retired as senior most judge of the Supreme Court in 2018. He is now a judge of the non-resident panel of the Supreme Court of Fiji, and by far the first Indian judge to become a judge of a foreign country. Thank you, Justice Lokur, for joining us today.
Thank you, Raj.
We have with us Professor Dr. Mahendra Pal Singh, a research professor of law and distinguished scholar at the Jindal Global Law School. Professor Singh was a chair professor, Center for Comparative Law at the National Law University of Delhi. Professor Singh was also the Chancellor of the Central University of Haryana, visiting professor of the Max Planck Institute for Comparative Public Law and International Law, Heidelberg. Before that, he was a chairperson of the Delhi Judicial Academy. Earlier, he was the Vice Chancellor of the West Bengal National University of Juridical Sciences, Calcutta. And before that, he taught at the University of Delhi, where he was also Dean and head of the Faculty of Law. He is my teacher and mentor. Thank you very much, Professor Singh, for joining us this evening. My first question is to Justice Madan Lokur. Justice Lokur, the Constitution is a social document, a key objective of which was to create and enable a social revolution. These were the words of Granville Austin. What role does the Supreme Court play in this constitutional evolution? How well has it done in exercising creativity and innovation in the progressive interpretation of the constitutional frameworks to maintain high standards of justice? With the landmark and progressive judgments passed by the court in recent years, has it indeed done enough to fulfill the larger promise of the Constitution in creating a social revolution? Justice Lokur.
Thank you, Professor Raj. You see, it's like this. I believe that the Supreme Court has achieved a great deal over the last maybe about 40 years. And one of the reasons for that, I think the primary reason for that is the fact that it has embraced public interest litigation. Public interest litigation began, as a social sort of objective for the benefit of the downtrodden, the marginalized, the depressed, poor people, and so on. And to that extent, I think it has done a great job over the last 40 years. I had the opportunity of presiding over the social justice bench when I was there in the Supreme Court. And the kind of issues that came to us, and the kind of problems that society faced, the marginalized sections of society, was truly amazing. And drawing upon precedents and also looking at, of course, what was placed before us by all the advocates who had appeared. I think, we did a pretty good job. The Supreme Court did a pretty good job in advancing the rights of the depressed classes. But at the same time, there is occasionally a sort of a break that comes in, a sort of a self-imposed break. Should we do this or should we not do this? I don't think that should happen frequently, and I don't think it should, frankly, I don't think it should happen at all. If you're doing the right thing, you're doing the right thing. There's nothing wrong with it. But if I was to look back, I would say that the Supreme Court has not done enough. And one of the reasons why I say it has not done enough is because what we saw during the last couple of months, the way in which the migrant issue was handled, for example, the way in which some protests, have been handled, for example. So I think there is a lot more that needs to be done on a variety of issues. But I will not take away anything from the fact that the Supreme Court has done a tremendous job over the last 40 years. But I would add that still there is a lot that needs to be done. Thank you.
Thank you very much, Justice Lokur, for that. Let me take that question to Justice Chalameshwar. Justice Chalameshwar, clearly when you talk in terms of the larger imagination of the Indian citizenry, the Indian citizenry has consistently placed enormous faith in the judiciary, arguably more than the legislature and the executive. So while the Supreme Court has provided leadership in drawing upon constitutional rights, the fact remains that several judgments have been unenforced. Now, how do we improve the enforceability and implementation of the judgments? The existing mechanisms of the Contempt of Courts Act, for example, or for that matter, continuing mandamus and other such suo motu ways by which courts can intervene, is that enough? Are they adequate even? Or we need to look at a more fundamental approach towards resurrecting and creating a rule of law society in which the Supreme Court's voice and its judgments are enforced absolutely.
Professor Rajkumar, while I agree in part with the other law court that the Supreme Court has done a great job in theory for a period of last 40 years. Some of those judgments of the Supreme Court have given totally a new dimension to some of the rights of the citizens under the Indian Constitution. But as you raise this question, to what extent these rights have been effectively implemented in this country, to what extent the common man in this country enjoys these rights, is a question which really me. I'm sure anybody who examines this question for the reason, I don't want to enter into any high-profile political issues debate. Yes, what is the most basic function and the most basic right of a human being under any constitutional governance, including Indian Constitution, is the life and liberty. When we talk about liberty, the administration of criminal justice system in this country, what is its present state? The problem of the under trials, the problem of the duration taken for investigating a crime and filing a charge sheet before the courts, and the time frame taken for conducting the trial by the trial court, and then the appeals, depending upon the nature of the case, how many appeals or revisions available on all these things. Can we say that all the law declared, all the great hopes created by the various judgments of the Supreme Court have really been translated into action is an area where I have my own doubts. I'll tell you, Professor Rajkumar, after you proposed this program, just for the sake of information, I asked one of my friends, the bar in the Supreme Court, to collect this information for me. Now, I'll give you some information. I may not be able to outsay for the accuracy of it, but broadly it is true. There are 382 references before three judges of the Supreme Court pending as on today, and 113 references before 5 benches, 12 references to 7 judges, and 90 references to 9 judges. They're pending before the Supreme Court for varying periods of time. Now, if this is the information available, it may be subject to some corrections of the numbers here and there. I'm not very sure. I have not calculated from this thing. No, but question is, first of all, the finality, because though you have a little modified the original statement, final but not infallible, of Jackson, supreme but not infallible. The question is, the fallibility of this, at least this doubtful thing in view of so many references pending, and the very fact that so many references are pending indicates that at least judges themselves, the judges of the Supreme Court themselves, are not questioning their authority or right to raise a doubt. It's very, very necessary and healthy also to raise doubts. But if so many are pending for larger benches, obviously there are doubts about the correctness of those judgments which are the subject matter of our reference. So in which case, it's not either final or infallible. There's inherent logic in these numbers that emerges from these numbers. And if these matters are pending for long years, what is it that, how can the Supreme Court make any statement that it has, well, protected the rights of the citizens? I'm not saying it's not protected, but then it has done the best. That is the problem. I'll tell you, for example, on the question of the interpretation of entry 54 of the list 1 of the 7th schedule, to my knowledge, there are about 8 or 9 constitutional bench judgments of varying from 5, 7, so on and so forth. Various judgments, starting from earliest some Rampur, Hingir, so on, so India, so all those matters. Then eventually matters got referred to a bench of 9 judges sometime before I went to the Supreme Court in 2011. The reference is still pending. And from 1961-62, that issue still lingers. So what is the finality in this matter? What is the infallibility in this matter? Now, the point is, this is inherent in a court which sits in division benches, unlike the American Supreme Court, which sits en banc, where an issue, if you recollect, Rajkumar, when in the Planned Parenthood case, when the question arose whether Roe versus Wade is still a good law, it is required to be overruled. The amount of debate that went on in there, you remember Sandra Day O'Connor's judgment, the philosophical debate she indulged in about the need to displace an existing precedent. In a country, in a court where it sits en banc, that kind of a doubt exists. And in an institution which sits in 15, 16 division benches every day, this finality is an illusion according to me.
Got you.
Whatever, sorry.
Go ahead, sir. Go ahead. Finish it, sir, please.
So, and coming next to it, to what extent did we achieve the constitutional goals? Just take one example, as I told you, the criminal law administration. Just take the number of under trials. How many people are in the jail, languishing in the jail, awaiting trial? If these statistics are taken, there is a lot to be done. I'm not saying the Supreme Court has not done anything, as is not at all. The point is there is a lot to be done, and then a more focused debate on what is to be done is more essential than patting our own back, saying that we have written wonderful judgments about it.
Thank you very much, sir. I think thank you to both our former distinguished judges in the sense of the court who reflected on the way we have evolved. And as we move in the discussion, we will take some of those issues further. Sita, let me come back to a very substantive question that the reflections of both the judges have raised. The heart of the problem is also to really dive deep into the court's functioning as an institution. I know that United States and scholars in the US have done significant empirical work when it comes to looking at the functioning of the very institution itself. So in what ways you think quantitative empirical work of the court can reveal certain fundamental problems relating to access to justice as well as dispute resolution? Now, what are the benefits of quantitative empirical work? Because I do think that such work is relatively less in the Indian context, and particularly in understanding the functioning of the court itself. Sita.
Thank you so much, Raj, and thank you, Jindal Law School. It's such an honor to be part of this illustrious group. I know Justice Shailaj Meshwar and Lokur and MP Singh are, absolutely experts in this topic. But one of the things that we've been working on with some of my colleagues, Aparna Chandra at the NLU Delhi and William Hubbard at the University of Chicago Law School, is a large empirical study of the Indian Supreme Court, which means that we've looked at and read every published case in a 5-year period. And the Supreme Court of India is very prolific, as both the justices know how hard they work. It publishes over 1,000 decisions a year. And we've coded and analyzed for various variables. So I think by doing this, you can learn a lot about what the priorities are of the court, what the reversal rate is, how long it takes for cases to go through. I mean, much of this data is public and not public, but we kind of also they put a lot of data on their websites, and so we can use methods like scraping the data. And I think, given that the Indian Supreme Court has, I always say, it's one of the most powerful institutions in the world. 1/6 of the world's population is under its jurisdiction, and given that there's, I think, too little research, particularly outside of India, done on the court and using sort of these methods. So I think some of the things, and I'm happy to talk about what I think it could reveal. One interesting observation with that some of our work has shown regarding the prior question that you asked, is it a court that provides access to justice, right? So we looked at rates of admission of cases when defendants are, for example, criminal defendants versus the government, as opposed to individual petitioners, right? And we found that actually there's more access to certain downtrodden, quote unquote, vulnerable groups of people at the court than there is to other groups. So they might admit more cases, but they're not necessarily granting those cases. So they're affirming a lot of the cases, which to us suggests that they're admitting weaker cases when people who are vulnerable are criminal defendants or others, just to say, okay, this individual may not have had their justice at the lower courts. Let's look at their case, and yet still they will maybe still uphold it at greater rates. So in that narrow way, it still continues to be, we believe, a people's courts. We have argued that in one of our articles.
Okay, thank you very much, Sital, for that. Let me move to Professor MP Singh. Professor MP Singh, you have had the privilege to look at comparative constitutional, evolution. You have done extensive work on, for example, the German administrative law, looking at the Federal Constitutional Court in Germany, and of course, India as well. So now, my question to you is that, given the impact of the administrative decisions taken by the governments can have on the constitutional freedoms and basic rights of the citizens, and given that the judiciary is one of the constitutionally enshrined checks and balances of our nation, what role can the judiciary play in specifically in enforcing rights and to ensure accountability of power holders? To what extent does the court have the responsibility of providing institutional leadership to influence, impact, and inform the mind of the legislature and the executive when it comes to adhering to norms of constitutionalism?
Rajkumar, just it takes me back to your beginning comment in one of the earlier webinars, where you started with that tryst with destiny speech of Nehru. In the same speech, he also said that with freedom also comes responsibility. And I have an impression, and I'm reminded of a story from Saadat Ali Mantoor, Naya Kanun, that after the Government of India Act 1935, he thought that now we have become totally independent and can do what we like, a Tongewala, therefore refused to obey the policeman. And he even fought with the policeman and even gave his beating also to the policeman. Then the policeman took him to the police station, and finally he was in jail. Now, the same kind of thing happened soon after the commencement of the Constitution, that there was a great enthusiasm to make those changes which the Constitution actually had envisaged. And of course, that exercise of power was legitimate, but at the same time, there were also excesses. As a result of that, many of the decisions which came from the Supreme Court, they created disappointment with the government. And as a result of that, actually, the First Amendment had to take place, which of course, made exceptions with respect to the application of fundamental rights those for those acts which are included in ninth schedule. Now, therefore, I agree with Justice Lokur that much change came after the introduction of this public interest litigation or social action litigation in 1980. And since then, actually, the things have changed very much, that people are also exercising their, or the states or the governments are also exercising their powers with some responsibility. But the judges are also now much more conscious about their responsibility with respect to common men also, apart from the interest of the government. They are also looking at what the constitution requires, which is as much in the interest of the government as it is in the interest of the people. And therefore, those constitutional values now are being enforced by the court as much as possible. But certainly, from all institutions, whether it is parliament or it is executive or it is Supreme Court, the expectations of the people are that they are not performing as well as they must. And to that extent, we may still say that there are many things in which the Supreme Court is not doing as much as it could have done. And the most recent examples have already been given by the two honorable justices, and to some extent, Kalantari also, she is working on these issues. And we come to the conclusion that there is much more to do than what the court has been doing so far. I'm not sure whether a change is going to come suddenly, but definitely we hope that with the increase of number of judges, much of the pendency of the important matters and particularly references which Justice Chelmeshwar has mentioned, they will be taken care. And these kinds of things would happen as if you are giving example of the German courts. The German court actually has become an ideal for the new constitutional courts in different countries. And the best example is of South Africa. So I hope that now there is a new consciousness, and with the changing times, the Supreme Court would also act with greater responsibility.
Thank you very much. Thank you very much, Professor Singh. For all the viewers, we are live on Facebook and YouTube. After the first segment of this program, I'll invite you to send in our questions, and I'll take up those questions with some of our distinguished jurists who are here. Let me move to Justice Madan Lokur. Justice Lokur, one of the things that is clearly, playing out here is that we need to hold our institutions constantly to higher standards as well. But at the same time, given the challenges of India's attempt to provide access to justice, there's an enormous set of expectations that Indian courts, particularly the Supreme Court, needs to deal with. So my question to you is that what role you think could the executive have placed in using its own informed understanding and judicially manageable standards to manage the state of order during the current pandemic? Many issues that have come to the forefront could arguably be because of the fact that it was not handled appropriately by other wings of the government, and the Supreme Court and courts have been in many ways somewhat forced to take cognizance. How does the court maintain the constitutional balancing act between knowing when to intervene and when to let the executive or legislature have greater power or difference to their own wisdom? How successful and effective has the court been as protector of rights, especially during the ongoing pandemic? Justice Lokur.
Yeah, thank you. You see, Professor Raj, your question, as I understand it, is really in two parts. one is the implementation of the laws, you know. So you have laws which are very good, enacted by Parliament, but not being implemented by the executive. I can give you several examples. You would have the Manrega, for example. It was not being implemented as it should be. The Food Security Act, not being implemented as it should be, in the sense that the food security commissions were not established. You had the Juvenile Justice Act not being implemented. The National Commission for the Protection of Child Rights, the post of the chairperson was lying vacant for 18 months until the Supreme Court stepped in and said, listen, either scrap the law or appoint somebody. So really, the executive has a very, very important role to play in the implementation of the laws. And if the executive does not implement the law, there is no option but for the court to step in. What is a citizen supposed to do? He says that, listen, there is a law. The executive is not implementing the law. What do I do? Do I just hang around, without any, remedy? Or do I come to the court and say that, listen, there is a law enacted by Parliament. It should be implemented. So that is one aspect of it. The second part of your question really deals with when should the court interfere. Now, normally, the courts give some leeway to the executive in some areas where the court does not have the expertise. Right now, there could be a myriad situations where the court does not have the expertise. But as long as the executive does its job, it may make a mistake. It's not that everybody does everything right all the time. So if the executive is doing its job bona fide, in accordance with law, perhaps the courts may not need to interfere. But if the executive is not doing its job, then, like I said, the courts have to interfere. So really, it depends on the situation on a case-to-case basis. If you look at the first, few judgments of public interest litigation, Bandhuwa Mukti Morcha. Now, bonded labor is abominable. Why is it that the law was not being enforced? Why was it necessary for the Supreme Court to interfere? Environmental pollution in the Mussoorie Hills. Why were limestone quarries being awarded to contractors just for the asking and causing pollution in Mussoorie and Dehradun? So or prison reforms, which Justice Chalmeshwar had mentioned. Why is it that we can't manage our prisons? And then what do you do? Somebody like Sunil Batra comes to the court and says that, well, this is what is happening. They're torturing prisoners. Is that the duty of the executive to torture people, to torture prisoners? So really, if the executive does its job properly, no arbitrary transfers. Oh, I don't like you. So therefore I'm going to transfer you from place A to place B. All right. You take on the son of some VIP, so I'm going to suspend you. Now, if these kind of things start happening, people are going to come to the court, and the court is going to intervene, right? So really, on the first part is the implementation of the law. The second part of your question, my answer to that would be that if the executive does its job as it should, in accordance with the Constitution, in accordance with the law, perhaps the Supreme Court would not need to interfere in so many cases. Thank you.
Thank you very much, sir. Let me move to Justice Chalmeshwar. Justice Chalmeshwar, you have, of course, retired from the court and left Delhi, and I believe living in more countryside of India. It might be a good opportunity for you to reflect about the state of law and justice. My question, partly jurisprudential, and then, of course, I'll ask a more specific question. The jurisprudential question is that most of what we're discussing today is that the judiciary, to a large extent, is constantly playing a catch-up role, where there are so many injustices and there is an attempt for the judiciary to and despite that, we still feel there is lots of pendency, vast, a little done, vast undone. So my question to you is that, is this the case that judiciary and law as institutions are effective only when there are pre-existing conditions in a democracy for it to become effective. And otherwise, there will always be aspirations and goals we will continue to only aspire to, and it'll be a far cry from the standpoint of the rhetoric of law on the one hand and the reality of injustice on the other. That's a part jurisprudential response I would like. But the main question I have for you is that, what are the most important areas of development for the Supreme Court of India? How can we improve the efficiency of the institutional mechanism of the functioning of the judiciary? How can we enable greater discipline to achieve the desired efficiency of the courts? And clearly, like all of you are saying, the backlog of court cases, how do you instill that faith among the people that our judicial institutions need to be pursued so that they can actually achieve justice?
Anyway, you rolled too many questions into this statement. As I understand your question, first of all, there is a vast gulf between the theory and practice, put it loosely. Are you able to hear me?
Yes, we can hear you very well, sir. Go ahead.
Okay. Now, and then why is it happening is one thing I understand. Second thing is how to create a more effective judicial system. Once again, we started with the Supreme Court. Now we are going on to the entire judicial system. There's nothing wrong with it, but then let us be very clear about it. Yeah. See, I'll deal with the second question first, Rajkumar.
Okay.
When you're talking about the efficiency of the system and the Supreme Court, of course, Professor Jain was mentioning the more number of judges coming. Well, of course, I may be forgiven for saying that. I don't think that's going to solve the problem. If the institution has no specific design how to handle this matter, the number of judges have increased from time to time ever since the creation of the court, but the dependency never went down. On the other hand, the more admission benches on a Monday and Friday, by the rule of probability, the more will be the dependency, because one more bench will admit a few more matters at least. It is within their lordship's discretion and their own satisfaction with the legality or correctness of the judgment. So anyway, that's not going to, in my view, is not going to solve the problem. See, when you're talking about this, first of all, whether you should think of continuing these multiple benches in the Supreme Court is something which requires a national. I don't say my views are final or anybody's views are final, but then there is required to be consensus on this, whether it should sit as one court at the highest level, and what should be. Second thing is, it's almost becoming a court of error, correcting the errors of the various courts in this country. Almost. As I'm sorry, I may not be misunderstood for saying this. And yes, Lokur gave the example of somebody's transferred because somebody didn't like the face of somebody. Well, it may be in theory a very wrong thing, Article 14 or 15, whatever it is violated. The point is, should it be dealt with by the highest court in this country in individual case? I have my own doubts about it. See, for example, I'll just tell you, questions arising under the local laws of a state, barring there are grave constitutional implications arising from that case, why should not be the High Court the final court in the matter? X is transferred in the state of Andhra Pradesh or Haryana from A place to B place. The decision of the Haryana High Court or Andhra Pradesh High Court should be the. We, as trained lawyers, we may be able to find out some loophole in every judgment. Maybe the arguments are always possible. The question is, there must be finality somewhere. Now, all these matters really required to be dealt by the Supreme Court is the thing which I have written. I'm not saying it for the first time. I said it many a time while I was still in office. From the bench, I said it. Whether all these matters. Now, instead of assuming for the sake of argument that the efficiency levels of the judiciary, at the High Court level or the subordinate courts level, is required to be improved, necessary steps must be taken to improve that efficiency if the Supreme Court believes so. But the Supreme Court taking up the correctional business in every case of error, I don't think is going to solve any problem in this country. This court will continue to have this kind of pendency forever to come. Increase the number to 100 judges is not going to solve, is my understanding. I'll be very happy if I'm proved wrong. I have no difficulty about it. In fact, if you recollect one of those old judgments, 1952, I think I don't really recollect nowadays, now that after I retired, I stopped remembering the finer details. One of those dissenting judgments, Justice Frankfurter wrote in certiorari matter, declining to interfere with one of those circuit court judgments. He said it's immaterial, something like this, not with the accurate reproduction of the statement. It's immaterial whether justice is done or not in these four relatively insignificant cases. But what is important is the role of this court as the ultimate lawgiver of the country would be damaged by if the court starts examining every error counted by every court in the country. Now, I think there is a great wisdom in that. No. Well, anyway, these are the situations which require a wider debate and a proper decision taken by all the stakeholders, the body politic as such of the institution. That's the only way to improve the. In fact, one of my perhaps the last judgment I find, there's a case from Gujarat. It was a case of 3 dead bodies and 6 or 7 injured witnesses. 1989, the offense took place. 17 people were put to trial. The matter came to the Supreme Court and eventually heard by a bench which I presided over, Justice Sanjay Kishan Kaul, as my colleague on the bench. It took almost 30 years for the matter to reach a finality. In between, a lot of witnesses died, a lot of accused died, and a lot of things happened. The report did not anybody interested can read that matter. And what is the efficiency we are talking about it thereafter? Actually, if you see, under the Indian text of the Indian Constitution, the right of appeal to the Supreme Court in a criminal matter is very, very limited. But a lot of matters, especially in 302 cases, almost as a matter of course, notice is ordered in these matters. Maybe for good reason, I'm not on the question. Therefore, something is required to be examined more concretely instead of discussing in abstracts about how to improve the efficiency kind of thing. Well, that's all.
Thank you very much, Justice Kalameshwar, for those very thoughtful remarks. In fact, part of the effort to seek judicial reforms need to reinvent some of our long-term held beliefs about what kind of notions of access to justice need to be created at an appellate jurisdictional level, and we will come back to that a little later as well. Seetal, let me shift gears a bit. There are numerous statistics illuminating the various dimensions of diversity in the Indian judicial system, and arguably there are challenges as well. The homogeneity of the Indian judiciary is well known, including in many parts of our history, the Supreme Court itself. How can we address the diversity deficit consciously, especially through judicial appointments process, law and public policy interventions, as well as better institutional practices? What are your views on the overall selection process of the judges of the Supreme Court as well? I mean, arguably, one of the things that remains a matter of great concern for all of us is that, consistently we have had far fewer women represented in the highest levels of judiciary, not just the Supreme Court, but across the high courts as well. Seetal.
Thank you, Raj, for raising that question. Of course, Justice Kalameshwar has kind of had the most important dissent on the issue of how do we deal with the appointment system, right? So currently, as you know, the Colloquium is a group of 5, mostly usually men, who appoint judges. And what has happened since 1993 in our study of appointments, about 120 of their appointments, only 7 of them have been women, right? That's about 6% of the people. Also, there hasn't been as much of a focus on caste issues. However, on the other hand, their appointments very clearly reflect the religious and regional diversity of India, right? So India is founded in 1950 on democratic values of democracy. It didn't have a uniform religion, a uniform ethnicity to hold it together, but so the court had to justify itself by having a broad regional and religious diversity. But over time, the Indian political democracy has increased its notions of diversity, right? You have more women in parliament, more women in education. And the idea is that we really do think it's important to have more representation. So I feel that, we can't really say it's a pipeline problem now. There are a lot of women who've come out and a lot of women in the bar. And even, our studies found that, of course, they disproportionately appoint high court justice. Chief justices of high courts are the people that they're most likely to appoint. And again, if there are not enough female justices, well, we should appoint more to these high courts. That's again something the Collegium can do in consultation with the high court collegiums, and also change the system, right? Sometimes take people outside of that system. So I think, one can, and as of today, there are female high court chief justices that haven't been appointed. So if you care about that diversity, you have to actually look for the people and prioritize that access. And how do you change it? I mean, maybe a more representative system could do that. I think that I agree that with many people who have said you don't actually need self-appointments to have an independent judiciary. It's neither sufficient nor necessary. There are other ways. It's one of the few courts I know in the world that appoints itself. Yet there's independence can be measured in many other ways.
Well, thank you so much, Sital, for that. Let me move to Professor MP Singh. Professor MP Singh, you have, of course, studied many, aspects of judiciary, not just in India, but also other jurisdictions as well. So my question is that, to what extent legal culture and judicial culture shapes the ability of institutions to develop independence and autonomy in drawing upon continental experiences as well? And an equally important aspect is that what is the scope for developing a serious discourse within India with regard to having the federal constitutional court type of a model, which is of course the German example. But in a way, how do we balance the aspiration of Indian judiciary and the constitution to provide justice to everybody who seeks it, and at the same time, if the justice becomes so far-fetched, so elusive, so long that it almost becomes meaningless, what Justice Telemeshwar talked about, the 30-year wait, or for that matter, decades-long wait. So how do you actually build that discourse in a country like India, where we can gradually move in the direction, particularly when our high courts have constitutional jurisdiction, which is supported by the Constitution itself?
Yeah, it's not only problem with the Supreme Court, it's also with the high courts. Actually, the Constitution was considered, and recently Professor Bruce Ackerman has put Indian Constitution at #1 among the revolutionary constitutions. So as a matter of fact, and earlier, of course, already long back, that Austin called the Constitution of India as a revolutionary constitution. And in the same breath, he had also said that that revolution has to be done with the connivance of the courts in India, that is the Supreme Court or the courts in general, and the rights of the people, as well as by the government, their implementation. They have to work together to bring the aspirations which have been introduced into the Constitution. That actually has not happened. Already Justice Lokur has mentioned the kind of cases which the Supreme Court has been handling. That is also an issue, that so far as the courts in other countries are concerned, their jurisdictions are comparatively restricted. That is, the jurisdiction of the Supreme Court of United States actually is restricted to constitutional matters. That also only where US constitutional matters are involved or a central law is involved. And therefore, the jurisdiction is very limited. And for that reason, they can also have the authority to decide which of these cases which are coming to them, they will decide. Somehow the Supreme Court of India has not been able to do that. And it has not been able to do that because there are pressing issues where injustice seems so apparent that it has to be taken up by the Supreme Court. So quite often it happens that once they reject or refuse to entertain a matter, but then they call back that no, this is important, we must handle it. And so far as the court is concerned, I think it is trying to do its best. But in view of the fact that the number of the problems that are coming to the court, that is so enormous that in spite of their best efforts, they are not able to actually provide quick justice in all those cases. As a result of that, the effectiveness of the justice is also affected. And as regards model, German model, there are also now problems. Initially, actually, they provided for judicial review only on what is called as the direct judicial review. That is, President of Federal Republic or the chairman of the lower house or the chairman of the upper house could send some matters to the court for its consideration whether they are constitutional or they are unconstitutional. But once they opened the approach to the Constitutional Court for the enforcement fundamental rights, now the Federal Court of Germany also is full of cases, and it takes number of years to decide those cases. And since the jurisdiction and the number of the judges is fixed, it becomes very difficult actually to decide. So this is a problem actually world over to a great extent. I'm not sure about the South African Constitutional Court, but this is happening in all the courts all over the world, where the courts are conscious about the rights of the people or their responsibility to ensure that the rights are realized. They are not simply to be written in the Constitution, they have to be realized. That is a responsibility which falls squarely on the courts. Otherwise, the Constitution remains unenforced. That revolution which it envisages never comes.
All right. Thank you very much, Professor MP Singh, for that. We are live on Facebook and YouTube. For all those viewers who would like to ask, send in your questions, please do so. We will get back to the Q&A session very shortly. Justice Madan Lokur, let me ask you the question that we have been debating, but from another standpoint. Mark Galanter, who of course is not able to join us today, famously observed that it is not that India is far too much a litigious society. What he said essentially is that it's not too many cases come in the system, but when they stay in, they take far too long to come out of it. They remain in the system. And he and Jay Krishnan wrote a longer article on that subject itself. So my question to you is that, to what extent, technology-driven approaches towards improving efficiency in the functioning of the court can help us address the larger issues of pendency? Of course, technology we know has other implications, the use of technology-driven applications for contact tracing, to the potential use of facial expression recognition software for lie detection, to the e-hearings. Technology can be an enabler, but also can come with huge issues of privacy as well. So my question to you is that, how do courts balance the use of technology for its own efficiency on the one hand, but at the same time, it doesn't undermine some of the core values of civil liberties that we steadfastly guard both within the Constitution and beyond. Justice Madan Lokar.
Yeah, thank you, Raj. You see, there are two aspects to this. One is the administrative aspect, and the second is the judicial aspect. Now, when you talk about technology on the administrative side, I think it can do wonders. Case management is something that we have not tried out at all, in spite of the judgment of the Supreme Court delivered way back in 2005, and in spite of the report given by Justice Jagannath Rao, which was accepted by the Supreme Court. There have also been studies that have been carried out, in the Supreme Court. I know one that was carried out on my initiative with the approval of then Chief Justice Kapadia by the Faculty of Management Studies, Delhi University. Earlier, there was one carried out, I think, by one of the IIMs, probably Ahmedabad. So really, if you look at the administrative functioning of the courts, and I'm not talking only about the Supreme Court, I'm talking about every court. If you look at the administrative functioning of the courts, technology can play a very, very important role. We have not been able to harness that, unfortunately. But if we are able to do that, I think many of these issues, about cases going from here to there, certified copies taking a long time, summons not being served, this, that, and the other, these small things, payments not being made, witnesses not being paid. I think all that can be taken care of. So that is one aspect where I think we need to, do a lot. To some extent, under the e-courts project, we have achieved quite a lot, actually, but it is not being used. Many of the applications that were prepared during the e-courts project are not being used by the courts even today. So that's on the administrative side. On the judicial side, I think we have to realize that whether it's artificial intelligence or whatever it is, no machine can decide a case, right? It can take you up to a point, but beyond that, it is the human mind which has to, to be applied for deciding the case. So, which is that limit, to which the to which technology can take us, or to which artificial intelligence can take us, or to which machine learning or anything can take us, any aspect of technology. That is something that we have to decide. Having decided that, we should try and reach that, objective or that goal. For example, searching for case law. Now, you have so many, of these databases, right? Excellent. Each one of them is excellent. Each one of them provides something, which is unique. Now, research has become so simple for judges. A judge can just sit down in front of a computer and find out what are the judgments that he wants. The problem is that there are 100 judgments on the same issue, so sorting out those judgments becomes a problem. But yes, he can find out whatever he wants, right? Or she wants. Technology can really help in that direction. Also, in writing, when you write something, there'll be a red line or a blue line or something which tells you that, listen, grammatically you made a mistake, or there's a spelling mistake or something. So these small corrections can also be made. So the canvas is very, very large, and a decision has to be taken, or some understanding has to be arrived at, that let's use technology in our judicial work, to this extent. Beyond that, technology cannot help, right? Databases can help. For example, let me just give you one small example of traffic offenses. Through technology, I can find out that a person has committed 10 traffic offenses. What was the nature of the traffic offenses? What was his condition, or the condition of the driver? Was it under alcohol or was it not under alcohol? There are so many parameters, about 30 parameters. So once those 30 parameters are filled up, the judge can take a decision. All right, I'm going to fine you 1,000 rupees or 2,000 rupees or whatever. I'm going to take your license. But that ultimate decision has to be taken by the judge. So technology can help to a tremendous extent in research, in giving the direction to arriving at a conclusion. And I think we should try and go in that particular direction.
Thank you very much, Justice Lokur. Let me move to Justice Chalameshwar. Justice Chalameshwar, one of the things that you did raise, and I want to ask you in the current context as well, the current pandemic has exposed us to room for improvement in a number of laws, right from the Epidemic Diseases Act of 1897 to the various labor laws that we have. What reforms and innovations do you foresee in the broader legal architecture of India so that access to justice becomes a stronger focus within the functioning of the Supreme Court itself? What role do you think the Supreme Court can play in facilitating this evolution when it comes to the enforcement of rights that we have been talking about?
I find it difficult to answer this question, Rajkumar, for this reason. See, you are asking me about the future, what role it can play. Why I find it difficult to answer is this. The Indian Penal Code and the Criminal Procedure Code are more or less a 150-year-old document. The Procedure Code underwent changes subsequently, but broadly the framework remained the same. And if after 150 years of the existence of these laws, if our system, in fact, I gave you the example of the last 1800 matter, where there are 3 dead bodies, forget about all other things. I don't know whether you read that. 2 people were convicted for an offense under 302. Neither the trial court nor the high court indicated what is the responsibility of these 2 of killing which one of the 3. If both of them are, if we have to assume, in criminal law you can't make assumptions like that, but assume for the sake of argument, if both of them are responsible for causing the death of all the 3 people, it would have been 3 separate charges and 3 separate convictions recorded. What sentence would be awarded, whether the sentences would run concurrently, all that jurisprudence as the Vice Chancellor. Simply, the court says they are convicted under 302 for life imprisonment. Sentence is life imprisonment. If you are not able to handle the situation, how can I anticipate what is going to, what reforms that can be brought about in this thing? I don't think I can answer that question.
All right, thank you so much, Justice Chalameshwar, for your very candid response. Maybe I will take that question to Seetal as well. Seetal, I mean, one of the things Justice Chalameshwar is raising is that the heart of the problem possibly could be the state of legal education in India as well. I think, the fact remains that we have 1,650 law schools in India. We're graduating 75,000 plus lawyers every year. We have over 1.3 million people who are, kind of considered as lawyers. So if we were to address the kind of issues that Justice Chalameshwar is talking about, we need to go through a legal education reform, a new form of radical reimagination of legal education. What do you think ought to be the contours of that legal education reform, particularly when you are in a country where the rule of law, at least before the current president, had something much more meaningful and important when it comes to the working of democratic institutions as well?
May I intervene for a few seconds,
please.
Rajkumar?
Please, sir. Please, sir.
Apart from the reform of the legal education, one more aspect perhaps is to be considered is that a periodic mechanism of auditing the performance of these people, the bar and the bench,
right,
the judicial officers at the various levels. And I think this is essential. Otherwise, this thing, it will go on like this. All right, I correct the judgment and then that's over.
Very
that's also an aspect. Please.
Absolutely. That's a very important point, including efforts in the judicial training and all of that. We'll come back to it. Yeah, please, Sita.
So let me just connect the question of legal education a little bit to the earlier question of how do we deal with delays in the Supreme Court, right? I think one of the things that I have observed in terms of comparing legal education to the US and in India is that India is a very much more of an oral tradition, right? The Indian Supreme Court hears so many admissions matters, 2 days a week it's spending on admissions cases. And that takes up a lot of time. So instead, if it were more brief based and where you could look at papers, for this US Supreme Court, cert petitions are just all on the papers. There's never an admissions hearing. That would also save a lot of time, right? So the answer for the court, as Justice Shilameshwar said, isn't to increase the number of judges, increase the number of time, and make the judges work harder so that the cases are resolved faster. The answer is to be more selective. Special leave petitions have increased to about like 90% of their plate. And as I think Justice Lokur had once written in an opinion that they should have some more standards for it. So I think one of the ways legal education can be improved in India is to really focus on writing and efficiency of writing and clarity of writing. And we could have in the US, you have a 1-year class that students have to go through just focusing on writing. And they're already postgraduate students, so they've already done this writing in undergraduate, right? So in India, they're learning both being an undergraduate and also postgraduate. So I do think, you are revolutionizing some of these things, Rajkumar, in Jindal Global Law School, and I think many of the other schools are also following suit.
Thank you very much, Seetal, for that. Let me ask Professor MP Singh. So one of the things that our judges and particularly Justice Shilameshwar, but also Justice Madan Lokur have been talking about is to what extent the judicial capacity is available for dealing with this. And I've always wondered that although the Constitution of India had a provision for appointment of a distinguished jurist as a judge of the Supreme Court of India, we've never had professors, academics, being part of the judiciary. Of course, the US has a very strong tradition. My own teacher at Harvard Law School, Elena Kagan, is now in the Supreme Court in the US for many years now. And she used to be a professor and she taught constitutional law for me. So my question to you is this part of a response that we need to consider in the future, where one of the aspects of diversifying the court will be to bring in strong academic traditions into the very thinking and process of administration of justice?
Yeah, Rajkumar, I think so far as the European countries are concerned, their professors are judges because association of the professors is considered to be a privilege for the court. And professor's job is considered much more respectable than the work of a judge. And therefore, not many professors are interested in becoming judges, but they are, of course, is a requirement to some extent, and therefore half of the judges of the Federal Constitutional Court of the of Germany, they are actually university professors. Now, so far as the common law system is concerned, actually university professors have not been given adequate recognition for the purposes of being brought into the judiciary. And for that reason, of course, so far as the American position is concerned, actually their training is such that most of them have worked before as judicial clerks, and there they have actually trained themselves in knowing how the courts work, and therefore with that background, when they come to the court on the basis of their previous knowledge, and just as you are mentioning, Kagan, Professor Ginsburg was my professor at Columbia, and she is also a Supreme Court judge. But these people actually, somewhere their background is different from the background of the professors in India. I am not saying that professors should not be appointed. They may be appointed, but how effective they would be, I am not quite sure. maybe that they come with new ideas, but maybe that they are not fit in the system as it works. So this is all a guesswork. Of course, there is always an opening, and it should be actually exercised whenever there is a possible case.
Thank you very much, sir. We are, of course, coming to the end of this part of the program. We'll quickly go into Q&A session, but I have another quick round of questions. Justice Madan Lokar, one of the things that you briefly raised, and I want to draw your attention, which is that one of the largest adverse consequences of the current pandemic has been the hardships faced by the migrant laborers and the various marginalized, downtrodden, and disempowered members of our society, who play obviously a very key role. Now, what can we take away from this experience to have a stronger social justice and social security mechanism so that our judicial institutions need not wait so long to respond when they see injustice out there?
That's a bit of a tough question, but I am not at all in favor of this ivory tower theory that judges should live in ivory towers. I do not subscribe to that. So the follow-up of that is that the judges must have their ear to the ground. How can that be done? One of the things is that judges in the Supreme Court and in some high courts, particularly in Delhi High Court, they have law clerks or law interns, who are young lawyers or students. So they get a lot of feedback from them, right? There are others, other ways and means of getting information. There's so much of information that is available on the internet, So you have to be alive. Judges have to be alive to the situation. They don't have to get influenced by that. Something like a media trial or something. The judges don't have to sit in front of a TV to see whether a person is guilty or not guilty. I'm not advocating that at all, right? But there are ways and means of getting information, interacting with other judges from different parts of the country. I can tell you, I have learned a lot about judging or about the judiciary by meeting judges of district courts, of high courts, in the National Judicial Academy, and in several other judicial academies across the country. So this interaction, tells you exactly what is happening, or it gives you a pretty good idea of what's happening around, the country. So really, it is necessary for the judges, to have their ear to the ground, to know what is going on, not give it those, ivory tower ones, I'm not concerned with it. If a case comes to me, then I'll see. Yeah, but then why do judges exercise suo motu jurisdiction? On what basis? The case hasn't come to them. They've taken it up, right? So that is something which is, involvement of the judges in society, which I think is necessary in some form or the other. Thank you
very much, sir. Justice Chalameshwar, bringing that question back into your thinking a bit.
Sorry?
I said one of the things that I want to bring into attention is that over the years, we've also seen development of both the state judicial academies and the National Judicial Academy. There was a point of time when the word training was considered almost embarrassing for the many parts of the judiciary. Now you have a situation where the judges across the country, including in the high courts and the Supreme Court, regularly go to these academies. So my question to you is that how do we, let's say, galvanize the consciousness of judges through these training programs, and those programs not end up becoming, building knowledge and expertise, but actually develop a judicial character? And how do you infuse a greater degree of, let's say, institutional autonomy through these training and capacity building programs so that judges are, when they are exercising their role as the judiciary, they become far more conscious of their institutional autonomy and independence that they are expected to generate. In a way, my question to you is that how do we avoid the enormity of the judicial difference that might end up undermining the faith in the rule of law? In the sense, how do you ensure that enormous judicial difference undermine the faith in the rule of law?
I can capture your question completely because it's breaking in between. Can you just summarize it again?
So my main question is that how do we ensure the functioning of the Judicial Academy and training programs are effective so that judges are able to exercise their role of institutional independence and autonomy better?
Now, Rajkumar, when you're talking about judges, once again, please remember you're talking about the Judicial Academy in general, not only the national level, at the state level also. So the judicial officers or judges who go to these things are at different levels. The same principles may not apply to all of them. The same system may not apply to all of them. And if you're talking about High Court, Constitutional Court judges, if you are talking about, I don't think any training, any judicial academy would give that independence what you are talking about. It is something which is to be acquired over a period of time in life by personality, by judicial training, because the legal system is such, it is supposed to impart that culture in a lawyer, that a lawyer should be independent and not be oppressed by authority of whatever sort. When you talk about authority, you need not necessarily be worried about the executive authority, even the authority of the hierarchy. A lot of factors in the system. Well, I have seen, I have known. I'm sure my brother Lokur would bear me out on this. Members of the subordinate judiciary feel a little hesitant to express their views freely in the presence of High Court judges. It's a matter of experience because it's a hierarchical system, and then so many things happen. And I have been noticing after the last 20 years, especially after the second judge's case, the Colloquium business, the judges of the High Court feel a little diffident to express views very freely in the presence of the Supreme Court judges, at least the members of the Colloquium, for whatever reasons you know it. And I'm not making irresponsible statements. I can give examples and illustrations of this. That's not the point. So therefore, this is something which will have to be developed over a period of time by the personality, the overall training of somebody. When the Colloquium or the government earlier or the Colloquium now or the failed National Judicial Appointments Commission or whatever it is choosing, this is an aspect which is to be taken care of. It's not simply counting which state, how many judges are there, which community, how many judges are there. This is not going to help anybody. I think this assessment is something which is to be made by whoever is the appointing authority. I'm not saying who should be the appointing authority now, but it's all over now. My views are on record. So, but this can't be imparted in a training institution.
All right. Thank you very much. That was very useful, because I think the judicial character that you talked about obviously can't happen through work in the judicial academies. Sital, what are your views on e-adjudication and technology-led dispute resolution? Are courtrooms, are e-courtrooms the future of law? What challenges do you anticipate for the legal fraternity in India? For example, is India equipped adequately with to sustain e-courtrooms, particularly at the lower level? We know that the Supreme Court of India and high courts across the country are actually functioning, although with different levels of efficiency. But will the reach of justice be restricted by India's limited internet penetration and create a new form of social and digital divide exacerbated by the lack of access to justice for people who don't have the required technology, the infrastructure, the e-based skills or resources? Seetal.
So as many courts have shared.
One second. India doesn't lag. It's America which is lacking. Galantery is not able to join.
That's right. That's right. I agree.
Right. So the point is that we might actually be less advanced in our technology because Professor Mark Ellenter had technological issues internet issues in joining. And yes, I agree. In dealing, I've done transnational collaborations and had classrooms with Jindal Law School and NLU Delhi, and there was no problem at all in any of our discussions.
No, but let me get some very important facts so that you can understand this better. So there is data now that only 10 to 12% of Indian households have electricity uninterrupted and internet connection, and of course a computer or something. So in some ways, and of course the district courts and then lower courts below have huge challenges with regard to use of technology. Clearly, we are of course privileged in terms of cities and
No, sure. The digital divide is present even in the United States. I mean, public school teachers that my kids are, they're teachers, they're going online, but the teachers don't have online access. And the students here in our rural community don't have online access. So the digital divide is everywhere. And I think, courts transitioning to Zoom-based hearings has been sort of something we've had to do to deal with the pandemic. But is this something we will do forever? I don't necessarily think so. So, and I think you should distinguish between appellate courts and trial courts. So for appellate courts like high courts and the Supreme Court, probably the lawyers and probably the judges have internet access and they may be able to carry on their work through Zoom, but I think you miss something with the in-person. I think you miss something with the discussions and the intonations and observations. But trial courts, I've participated as a lawyer in a hearing where my client was in a video. All the immigration courts in the US many of them have pre-pandemic moved to video conferencing. So the judge will be sitting one place and the in detention, the immigrant will be sitting in another place. So as a lawyer, not being able to speak to the client is really problematic. And when you're also in front of the judge can't observe the viewpoints. So I think it wouldn't really work in trial courts. But I think what would work, and I think what's interesting about what we've learned from this is that in the past, courts have not aired their hearings. So I think even when we go back to in-person, they should continue the public Zoom airing. So the US Supreme Court has, for the first time in its history, had live participation in the oral arguments. And I think that holds judges, particularly at the lower levels, more accountable if they know that somebody is watching, right? So NGOs in India, many of them have this court watch feature where when people will just go sit in the court to ensure that the judges show up, ensure that they're not saying sexist things, they're not doing casteist, that they're properly implementing the law, right? So I think that could be one great innovation we take from this. Another innovation we might think about is whether we have these mobile in rural parts of India where often there is no access for judiciary. Maybe there's a panchayat, maybe there's courts that are smaller community based, but you could bring in judges through like a mobile van, right? Currently judges have to travel. In some cases, they travel to rural communities, but that can take a long time and they can't have access. So you could bring in just the judge in civil cases through video technology, and the litigants could be there in person. So there's, I think, some things that we can learn from, that we grow from, some things that we should just do for the pandemic, and and some things I hope, again, as I said, that we continue.
Thank you very much, Seetal. We are, of course, coming to the end of this program and I have 50 plus questions. So I'm going to take some of them. Before I do that, last question for Professor MP Singh. Professor Singh, one of the things that we are struggling within the court system is that to what extent the Supreme Court of India is advancing the cause of jurisprudence, while in the sense that how are they guided by academic writings, scholarly works of researchers and law professors? Because one of the remarkable things about many other parts of the world, including United States, UK, Australia, even South Africa, but also other parts of the world, including Europe, is that the courts rely significantly on academic writings and scholarly work of professors. Of course, historically, there have been such things in India too, but in more recent times, the Indian courts, the Supreme Court of India including, have little and lesser opportunity to draw upon that work. So how do we think we can address this problem?
I think to some extent, credit also goes to the professors. They have not developed to that extent to which professors in United States or professors in England or professors particularly in European countries have raised themselves. It is in a way they are the lawmakers or trendsetters. And now that kind of level professors have not yet reached here. I am not saying that there are no exceptions. There are exceptions, and some people also feel that once such opportunities are given, professors can actually develop those talents or those qualifications for the purpose of becoming efficient judges. But there is so far, I think by and large, that level, that kind of work which the judges have to do, perhaps, and in all fields, that it is not a kind of distinction which is drawn in European countries between public law and private law. For example, Constitutional Court in Germany has nothing to do with private law. It is a court only of constitutional law, which is considered to be a branch of public law. And therefore, the professors who are experts in public law, they are appointed to the Constitutional Court and not the ones who are in private law. Now, our courts are actually dealing with all sorts of matters, and whether our professors are experts in all those matters, the way the lawyers actually get trained in all kinds of matters through the kind of cases that they take to the courts, perhaps I am not sure about the foundations of the professors in that regard.
Thank you very much, sir. All right, let's thank you to all of you. I'll quickly move to some questions. I mean, honestly, I have received 60 plus questions. I'm going to randomly pick up a few. Is Justice Madan Lokar still around, sir? Are
yes.
You there? Okay, great. So there are questions which are focusing on the very, a sort of an assessment to what extent the Supreme Court of India has contributed to the vision of social transformation. Bala, Jyoti, Pradeep, Bhattacharya, and many others are talking about that, to what extent the vision of the constitution makers has been effectively translated by the Supreme Court of India.
Well, like I said in the opening question that you had asked, I think the Supreme Court has made a tremendous contribution. Things like environmental law, for example, right? The rights of prisoners, under trial prisoners or even prisoners, convicted prisoners, tribals. I mean, there's no shortage of issues, where the Supreme Court has brought about a transformation. But I think that there is still a lot to be done. We have achieved quite a lot, but there is still a lot to be achieved, and I think the pandemic, is really, at least as far as I'm concerned, it really brought out, a huge disparity between, the privileged and the non-privileged, or the haves or the have-nots, or, however you wish to classify people. But yes, there is a lot to be done, but let's not take away anything from the fact that we have done a lot. The Supreme Court has done a huge amount.
All right. Thank you very much, sir. Justice Talameshwar, there are a number of questions. Chinmoy Roy, Sadanand Pandit, Srihari. This is all about appointment of judges. Of course, everybody knows your dissent.
My views are already on record. What is the point in asking me again?
Yes, I know. But the larger question that is being asked also is about the fact that to what extent we can infuse a greater degree of responsibility on the part of the executive when it comes to not delaying the process, because there have been instances when even after the Supreme Court Colloquium has recommended the appointment of judges, there have been significant delays, and that has affected the administration of justice. So how do we impress upon that? Several questions have come, so I thought it's important for me to bring it to your attention.
Well, Rajkumar, see, as you have stated, that even after the Collegium cleared the names of the government, it doesn't clear the appointment process. Well, what is it that that can be done in a democratic society? And it's not happening today. It's been happening for long years. It just did start today or yesterday or 5 years back. It started 20, 30 years back. This process. Only thing is, well, we have more avenues of communication today, internet, WhatsApp, this, that, and all. Therefore, we get to know information much fast. But maybe earlier times, it took long time to information to come out. That's the thing. It's always happened. Now, it's a political process. It depends on the maturity, the democratic maturity of the society. But now, except creating a public opinion in this matter that this is not acceptable, nothing else can be done.
Got you. Thank you very much, sir. Seetal, there are a number of questions. I thought you will be more comfortable to answer this question than our distinguished former judges here. These questions are about, what do you think about the retirement age of the Supreme Court judges in India? What problems, administrative or otherwise, does it cause when the retirement age is 65? How does it compare to other countries as well?
Right. Thank you, Raj. So, you know, as many people know, the retirement age is 65, and this is sort of a colonial continuity from the Federal Court of India, when the age of life expectancy was much shorter. So as life expectancy has increased, judges, you know, want to and need to do something after they've retired, and the pension and the benefits don't exactly match. So often, right, there's this question which has been raised as with the appointments of Justice Gogoi to the parliament. This conversation has happened in India, is what are they doing after they leave? And many of them do take government jobs. And one study has found that when they're closer to retirement, they're in fact more likely to pander to the government than judges that are farther away from retirement. So there's some troubling features that empirical researchers have already observed with the fact that the age of retirement. Now, what's interesting is that if you look at all the Commonwealth countries, over 80% of them have a retirement age of over 68, and 70% of them have a retirement age of over 70. And then when you look at countries that have some judges, in some countries, there are term limits, right? We've talked about the South African Constitutional Court. The term limit is 15 years. On average, the term limit is over 6 years in all the countries. We did an empirical study of all the Supreme Courts all over the world. And if you look at the average, and we've also looked at what is the average time a Supreme Court judge spends in India, you know, starting in the last decade, they spend less than 5 years on the court. So that creates a lot of administrative issues and administrative problems, especially when the CJI typically only spends 1 year on average on the court. And that, I think, creates many administrative discontinuities. So I think it's really, one thing would be very wise for Parliament to do is to amend the age of retirement to make it a little bit higher so that we can avoid some of the problems of post-retirement jobs, and as well give longer period of time where judges become more trained in what they're doing, they become more skilled, give them more time in the judiciary to do their jobs as these ages of expectancy are increasing.
Thank you very much. So would you say 70, 75? What would be your recommendation to our, let's say you know?
I think the most, if you look at Commonwealth countries, right, if you think that that's your comparative base, if you, as opposed to all countries in the world, 70 seems to be the right number. you can move to life tenure like in the US, but that's going to be a bigger shift in the Indian polity than simply increasing the retirement age.
Thank you very much, Sital, because in fact, the life expectancy at the time, at the dawn of independence, was in the 30s, and today the life expectancy has actually moved up to 72. So there is the case for that as well. Thank you, Sital. Professor MP Singh, there are questions which have come about Jaya, Gautam, Devesh, Vandana, Madhumita. This is a question, in some ways, that's where Justice Chalameshwar ended, which is that a lot of faith and trust and belief in our institutions of justice, it presupposes that when they do something, others will listen, whether it is the executive or the legislature or even other institutions of governance. What happens when they don't listen? And an equally important answer is that how do we build a society where we can actually improve the adherence of the rule of law?
Yeah, it is interesting, Rajkumar, to know that people in villages have greater respect for the courts, and particularly so far as the Supreme Court is concerned, that whenever a judgment has been given or a direction has been given by the Supreme Court that such and such thing should not be done with respect to, for example, for brick kiln owners on the lifting of the soil, some restrictions were put by the Supreme Court. Every villager was conscious about that. And the fact that the Supreme Court has said so, that is considered with greater respect than the government has said so. So that is something which I have noticed from my personal experience, that is the case. So the courts are not unknown so far as the people in general are concerned, but so far as the ways of ignoring them, I think among the enlightened people, perhaps they find more ways of ignoring the courts than the ordinary person. Ordinary person may not like to go to the court, that is another matter. And that happens quite often because the procedures are complicated, they take time and all that. But so far as the respect for the courts is concerned, they have greater respect so far. It is another matter that they may not be having same kind of respect for their local courts of the magistrate or of the district courts. But definitely so far as the high courts and the Supreme Court particularly is concerned, people see them with greater respect. And once they hear that the Supreme Court has decided something, then they care much more than what they do when the government has decided something.
Thank you very much, sir. I know we are running out of time, but there's a question for Justice Madan Lokur. This is from Manasa Krishnakumar. As a matter of interest and curiosity, does the law in Fiji protects the liberties of citizens in the same way as ours? And what could be possible comparisons between India and Fiji in this regard?
Yeah, well, thank you for asking that. Yeah, well, Fiji is a Commonwealth country. So the people in Fiji have the same rights that we do in India, and they are equally protected. Right? It's a closed society in the sense that the population is not too much. Their judicial system is pretty effective. And, one of the things that impressed me a lot in the Supreme Court, and which was, mentioned at some point of time, I think by Sital, that, there's a time limit for submissions to be made by lawyers. They are given 40 minutes each side. So most of the work is done through the written briefs. The written briefs are given to the judges. We go through them, right? And then 40 minutes is given to the lawyers. And out of the cases that I did, there were only 2 cases in which we permitted the lawyers to exceed 40 minutes because we were not very clear about, what was the points ought to be made. but most of the lawyers finished within 20 to 30 minutes. So I think there is great value in having written briefs. So to that extent, there is this difference between the Fiji Supreme Court and our Supreme Court. But by and large, so far as rights are concerned, it is the same. Just one, intervention, if you don't mind.
Please, sir.
Justice Sharmeshwar had talked about, delays about in the executive accepting recommendations made by the Supreme Court for the appointment of judges. Now, I did speak to a couple of Chief Justices when I was there in the Supreme Court to say that, why did you talk to the law minister and find out, what is the reason? And the answer that I was given was, okay, I'll write a letter to him. The letter may have been written, may not have been written, I don't know. But I think if a phone call had been made to the law minister and, you just sit down across the table and say, listen, what is the problem? Why are you delaying it? It's much more effective than just sending a letter, right?
I suppose the formality of the judicial mechanisms of governance, I suppose, makes people reluctant to do that. Do you think that could be the case?
I don't know, what's the harm? Okay, you write a letter, you write a letter, but then also speak to him.
Well, in most other settings, we do exactly that. Just, you know.
I mean, the law minister is not the enemy of the Supreme Court. The Supreme Court is not the enemy of the law minister. Why can't they sit across the table and say that, listen, I have made these recommendations. What is the reason for the delay? And we'll thrash it out. There may be a good reason. There may not be a good reason.
Yeah, thank you so much, sir. Yeah. Justice Telmeshwar, there's a very interesting question from Om Sapra, and this is connected to the delay bit, but I'll keep it short. It's a longer question. Is asking whether limits can be imposed with regard to the matter being in the court. I mean, what kind of mandatory limits in terms of years within a certain time judges should be disposing of cases? Would that actually help?
When the time frame for decision making.
That's right. Correct. Yeah.
Well, if somebody wants to make a rule or law about it, well, anyway, that's a different matter. It is, as far as the system as it exists today, once a matter is heard, generally, barring exceptions are always there in any system, generally the decision is rendered within a reasonable period, maybe 2 weeks, 3 weeks, sometimes. Even some of the more complicated matters. Some of the matters we decided on the spot, in the sense the judgments are dictated from the bench itself. Now, well, there have been unfortunate instances where matters were pending for quite long with some honorable judges. How to deal with them is just by making a law. Will it really help? I don't know.
Got you. Sital, quickly, this is about dispute resolution, ADR type mechanisms. I mean, in India, we of course have evolved it, but there are lots of inefficiencies. So, drawing upon US experience, has ADR been an effective tool for dispute resolution in the United States, and other lessons for India? Several questions have come on that.
Right. So, alternative dispute resolution is a broad term which can include both the arbitration type scenarios versus, or more community courts. I think, you can think about here in the US, I mean, yes, people do, a lot of businesses in contracts have arbitration provisions, and but they're doing it for a different reason. In a way, in India, often they're avoiding the courts because they think that it would take too long to resolve the issue. Here in the US, they're not necessarily avoiding the court for that reason, because they think maybe this is more sophisticated business issue. A lot of the things here, we have Delaware is a state that, and courts that people think, okay, well, they can resolve these sophisticated issues because they know about it, but otherwise they might do arbitration. Also, in some things that I've negotiated, when it's an international deal, arbitration is actually in a way more enforceable internationally because of a provision, a treaty, than sometimes just a local judgment is awarded. So I think, before we get to ADR in India, I think we need to really improve the efficiency of the system itself. and how do we make sure that, as I said, the Supreme Court is really already two courts, where there's the Constitutional Court that's doing these high-level cases, and actually, at the top 20th percentile, they're moving cases along very quickly. 90% of their cases, in 90 days, the top cases are resolved, but the bottom percentile cases are resolved in 8 years. So you have to be a little bit more nuanced about figuring out how to solve the issue. It requires a little bit more nuance in understanding how the court is currently functioning.
Thank you, Sital. And Professor MP Singh, there are questions on the future of legal education, but heart of the question is that how do you inspire young law students to take up the legal profession and not just limit to corporate bar, including aspiring to become a lawyer or a judge or even an academic as opposed to other pursuits?
I think best of our students, normally they go to practice. They rarely, they are not so keen to join law firms or even law firms or to join something else. They would rather go, even after taking higher education, they will go to practice, which they consider as a greater challenge, as well as opportunity to serve the people. And therefore, already so far as we are concerned, that is the education part is concerned, I am not quite sure whether at the law school we can give that kind of training which actually the lawyers get in the courtroom. And therefore, I would not suggest that we should make the kind of changes which we have tried on the lines of the Bar Council of India. But definitely, so far as the academic levels are concerned, and particularly with reference to specific cases in which the kind of issues are raised and generally raised by the judges in court matters, if the professors can teach the students with reference to them, that would actually be an effective way of making students more interested in the courtroom functioning.
Thank you very much, sir. We have, of course, come to the end of this program. I have one last question to all of you. For the students of law who are watching this program, what would you like to tell them as they experience the uncertainty of this COVID-19 global pandemic, along with the studies in law schools? There are, of course, students who are graduating this year and are assuming a great degree of uncertainty for their own future as well. And for the two judges in the program, what would you like to tell some of those students who also have aspirations to become judges like you in the future? Let me begin with Justice Mandalok.
Yeah, thank you, Professor. Well, I would like to tell the students or the young lawyers that you have tremendous opportunities. Not the kind of opportunities that we had when we were law students. So you have tremendous opportunities. Number one, take advantage of it. Secondly, there are a lot of challenges. We did, of course, have challenges when I joined the legal profession, but the number of challenges has increased. The number of problems, the number of issues, the number of laws. I mean, it's been a sea change from the time when I joined the bar. So there are a sea change in the opportunities, a sea change in the challenges. I think you should grab, the opportunity with both hands and resolve those challenges. Okay, you'll be doing a great service to the legal profession. You'll be doing a great service to the people of the country and to the country itself. So yes, I think you should do that. How should you become a judge? I don't know. Well, work hard, I suppose. Wait for the opportunity, wait to be recognized by the Chief Justice under the present dispensation of the Colloquium system, and hope for the best. Yeah.
Thank you very much, sir.
Thank you.
Thank you, Professor. Justice Chalameshwar.
for the benefit of all the youngsters, I can only say this. There is no substitute for hard work. And also get rid of these beliefs. Success and accomplishment are one and the same. Somebody can be very successful with a limited accomplishment. Somebody who's highly accomplished may not be that successful in terms of financial success, or professional success, or recognition. The question is, I would advise, since you asked me, no, I'm old enough to advise others now. Never compromise on your self-respect. Never give up your values. What values you want, you fix them. And don't compromise on those values. I wish you all the best. Hello? What happened?
Thank you very much, sir. Seetal. Seetal, over to you. Professor MP Singh, why don't you give your...
Raj, I think there is always a place at the top. So whether it is academics or whether it is practice, whatever the students want to choose for themselves, if they do well with sincerity, I think there would always be success. So from my personal experience, I can say that much to the young students, that try hard, work hard, and have your clear goals, whether you want to be in academics or whether you want to be in practice and you want to be a judge. This is your decision. You may decide to do one or the other. But I think there has to be an aspiration, and accordingly there has to be a work also.
Thank you very much. Seetal.
So I think this is a terrific time to be a law student coming up. You have the ability to stand on the shoulders of giants, some of whom are even on this Zoom call. Many of my students early in the pandemic were concerned that they would be unemployed or wouldn't have jobs. And now I'm talking to them and they have summer jobs over Zoom and they don't have time to talk to me. They say, we're so busy, professor. So really that you shouldn't worry about. But I think what you should also think about is how you can contribute to providing access to justice to the people who need it, right? India and many societies, it's so split. You have the migrants, the poor people, the domestic workers, be their lawyer, do it for free, take cases on the side. In the US, there's people even who work at firms do pro bono practice, and they will take some percentage of cases that involve issues that help people. So in the beginning of this call, we're talking about access to justice. That just doesn't happen. People don't just go to the Supreme Court. A lawyer has to take them there. So it's your role as a new lawyer to ensure access to justice for the people in India that need it the most and that can't afford it.
Thank you very much, Seetal. And first of all, let me say how gratified we are. Thank you to Honorable Mr. Justice Madan Lokar, Honorable Mr. Justice Chalameshwar, Professor MP Singh, and Professor Seetal Kalantri for joining us in this discussion. We deeply appreciate your candid contributions to this colloquium. I also want to thank you for your leadership and indeed your contributions to inspiring the evolution of law and justice in this country and beyond. I also want to thank all the persons who participated in the discussion. I'm sorry that I couldn't take over 50 questions that have been left unattended, but thank you for your very presence. I also want to thank our knowledge partner, Live Law, who also contributed to this discussion. This has been an extraordinary discussion today for me personally, because we could understand the functioning of the Supreme Court of India, but also addressing some of the issues that are going to confront the future of law and justice. I'm reminded of the famous words of probably the most distinguished lawyer of the last century, Mahatma Gandhi, when he said there is a higher court than courts of justice, and that is the court of conscience. It supersedes all other courts. While that may be the case, we also need to recognize that the Supreme Court of India has played an extraordinary role in shaping and strengthening the democratic institutions of India. The future of this institution will depend to a large extent how it is able to perfect its own functioning, but not to be hesitant about developing an internal critique of its own functioning. And that is precisely what was attempted during the last couple of hours. I'm grateful to each one of you, sirs, and Seetal, for your presence, your participation, and in your time. This is part of a public interest initiative of Open Jindal Global University. Every week we hold 2 colloquiums. On Wednesday, 22nd, we'll be back on discussing global legal education colloquium on the theme, higher education and research in law, preparing the next generation of legal thinkers, lawyers, academics, and judges. I'll be joined by Mr. Adam Kolkar, Assistant Dean of Columbia Law School, Mr. Vikram Raghavan, Lead Counsel, World Bank, Ms. Jane Shukowski, former Executive Director, United States Educational Foundation, Argya Sengupta, Research Director, Vidhi Center for Legal Policy, and Dr. Surat Singh, Senior Advocate, Supreme Court of India. Till then, thank you very much. And thank you so much, sir, and Seetal, for all of your presence.
Thank you. Thank you very much.
Thank you very much.